taste of a typical law school classroom experience here today, and I thought I would take advantage of this opportunity to do something that's been on my mind for a while. To stand up and to proudly say, God bless America, God bless the Bill of Rights, and thank God for the Fifth Amendment. I'm not ashamed to say I'm proud of the Fifth Amendment, and I'm proud to admit on camera and on the internet that I will never talk to any police officer under any circumstances, with all due respect, sir. I'm doing something really extraordinary here today, something you'll almost never see another law professor do as long as you live. I'm really putting myself on the spot here. This was my idea. By my invitation, I have given up half of my time, approximately. I'm giving equal time and the last word to an expert who really knows something about what I'll be talking about. So I'm opening myself up to the possibility that he will contradict me. I was a criminal defense attorney when I was in private practice. So I want to make sure, in fairness to you, if I'm misleading you or giving you a slanted or one-sided presentation, you'll be able to get the last word from somebody else. I'm sure he'll have a lot to teach all of us, including myself. The Fifth Amendment to the United States Constitution provides, no person shall be compelled in any criminal case to be a witness against himself. And this unfortunate amendment has gotten a bad rap in recent times, much of it tragically and unnecessarily through, as you may have heard, the headlines. Let me read to you something that was taken out of the newspaper this morning, and I want you to listen to it closely. And I'm giving you a heads up. I'm warning you in advance, which is not fair to you. Not fair to me, but I'm giving you a warning that I'll be quizzing you on this in just a few minutes. This will test your aptitude for legal study and legal practice. Listen closely, it won't take long. Last night, agents of the Norfolk Police Department found 3 victims of an apparent murder dead in an apartment in the East Ocean View area. The apparent victims of a gangland-style slaying, and possibly the victims of gang-related violence. The police are investigating this as a possible murder and suicide, but right now suspect that the 3 were all killed by the same individual. No suspects have yet been identified in the slaying, but veteran police detective George Brook has confirmed that police are following up on evidence pointing to the possible involvement of an off-duty naval officer as the perpetrator. The bodies, which were found by the apartment manager at about 8 o'clock in the morning, appear to have been slain sometime earlier in the same evening, probably sometime between midnight and 2 o'clock in the morning. That's it. Those are all the facts I'll ask you to remember, and it won't be for very long either. Let's see how well you do. I'll be quizzing you in just a few minutes. Now, here's the easiest question you'll ever get from a client in all the days of your life. Question, hey, the police are here, they want to talk to me. What should I do? Well, I could give you my answer to that question in case you haven't already guessed it, but why don't we go to a real expert? Justice Robert Jackson, a prosecutor's prosecutor. Like me, he began his private practice in Buffalo, New York, years before I did. And after that, he served as general counsel for the Bureau of Internal Revenue, the U.S. Department of Treasury, the Security and Exchange Commission, Assistant U.S. Attorney General for the Tax Division, later the Solicitor General and the Attorney General of the United States, and then the Chief U.S. Prosecutor for the Nuremberg trials. That's an impressive resume. Years later, when he was a justice on the Supreme Court, Justice Jackson stated, quote, any lawyer worth his salt, today we would say his or her, will tell the suspect, his client, in no uncertain terms to make no statement to the police under any circumstances. There's the title of my talk. I'm here to explain to you the surprising and somewhat counterintuitive and admittedly unlikely reasons why Justice Jackson was right. I'm reminded of this because I'm amazed, we're all amazed, by the frequency with which we see newspaper articles coming out all the time from people who really ought to know better, who say, well, I'll talk to the police. I mean, after all, I'm a senator. I'm O.J. Simpson. I'm an experienced, highly polished individual. I've got a lot of experience with public relations, even criminal defense attorneys. There was a local news story here in the Virginia Pilot just a couple of months ago about an experienced criminal defense lawyer who ended up getting convicted of criminal assault because he talked to the police. He was accused of having assaulted another attorney in the hallway. There were no other witnesses to this. A woman said that he grabbed her by the throat during an argument over a case. He denied it. At trial, it was his word against hers. He said, I did not even touch her. To a police officer who will explain to the extent to which, if any, he agrees or disagrees with anything I've got to say. I have no idea to know what he's going to say, but it'll be interesting. Here, let me give him the microphone. Let's give him a hand. Officer George Brook, the Virginia Beach Police Department.
I cannot talk that fast. Not even interviewing. I'm going to take the podium here, Professor. Because I took notes on some of the things you said. And everything he said was true. Okay? And it was right, and it was correct. And I'm just going to give you a few ideas. I'm going to tell you a few examples. But first, I'm going to give you a little information.
If you're walking on the street and a police officer asks you for your identification, do you have to provide it? If an officer asks you a question, do you have to answer it? Those questions are kind of complicated, and I'm here to discuss very briefly those complications. I'm Professor Dan Capper from Fordham Law School. The answer is, as in most legal questions, it depends. If an officer walks up to you and asks you for your identification, that is a consensual encounter, if that's all that they do. The idea of a consensual encounter is that the officer can do it without any kind of suspicion at all, because it's not considered a seizure under the Fourth Amendment. Because it's consensual, that by definition means that you don't have to comply. You can just say no. You can just say, I'm not giving you anything, I'm not letting you do anything, I'm not giving you my ID, I'm not going to answer you. And technically, that is what can happen. Unfortunately, in reality, that's what never happens. In other words, what happens on the ground is different from what might happen in under the Fourth Amendment law, as it were. At any rate, at least the law says that you don't have to comply with a police officer's encounter. You do, however, have to comply if an officer stops you, has reasonable suspicion. Then one thing that the court held in Terry versus Ohio and in later cases is there is an automatic right for an officer in that circumstance, once they've stopped you for whatever crime that might be of reasonable suspicion that you have committed it or about to commit it. You have to give them your ID if they ask for it. Actually, the major investigative tool that's permitted during a Terry stop is determining who you are. And so there's no right to refuse to give identification in that circumstance. There's no Fifth Amendment right. There's no Fourth Amendment right. That's basically something that has to be complied with. In terms of a search of the pockets, that's a little bit different, or a search of somebody's pocket or backpack or whatever it might be. That need not be complied with either in an encounter, of course, because it's completely consensual, but also even in a stop. Well, of course, they can ask you to comply, but you do not have to comply. And the reason that is that the officer's search powers under a stop and frisk are limited to weaponry, reasonable suspicion that there are weapons. So they can't simply ask you to, or even order you to turn over what's in your pockets, unless they have suspicion that there's a weapon there. And generally speaking, there's not going to be a weapon that could hurt them in, for example, a pocket. At least that's true in most cases. So basically, there are kind of dancing rules between the officer and the suspect that not many people know in advance. And officers don't always comply with when they come into these situations. But those are the rules. And giving you these rules is Professor Dan Capper from Fordham Law School, and I'm here for Talks on Law.
I'm standing out in public taking pictures.
Okay, why are you taking pictures of vehicles?
Just because I'm standing out in public taking pictures.
Okay, do you have any ID on you?
No. Have I done something wrong?
It's a little suspicious if someone's taking pictures of license plates leaving a secured building.
Is that a misdemeanor or a felony?
No, it's suspicious.
Okay. So why do I need ID?
Because we need to know who you are.
I don't think so. If I've not committed a crime, I'm not giving you ID.
323. Sorry, George, you heard the subject's refusing to provide ID or identify himself.
Can you see me, please, sir?
Yeah, sure. I have no weapons. I have nothing on me.
Okay.
I have my phone in this pocket, that's it. Like I said, I'm out in public taking pictures. That's
right.
it.
But again, you're taking pictures of people leaving police vehicles.
Okay.
Police vehicles from a police parking lot.
Okay.
That's suspicious.
Is it suspicious? Is that a crime?
It's not a crime.
Okay,
It's
so then,
suspicious.
am I free to go or am I being detained?
You're being detained right now.
Okay, can you tell me the crime?
We're detaining you because of your suspicious activity.
Is that a crime?
Okay.
Am I being detained or
We
am
need
I
you to
free to go?
provide some sort of ID.
Am I being detained or am I free to go?
You're not free to go right now.
Okay,
No.
so I'm being detained. Can you articulate a crime?
We don't know that you haven't committed a crime yet.
Okay, so once you figure that out, I'll provide an ID. Until then, am I free to go?
No.
Okay, so then I'm just gonna remain silent then. I'll also need your name and badge number, please.
Sure. Officer Britton, 2085.
Your name, badge number, sir.
Detective Forbert, 2081.
Thank you, ma'am.
Detective Codes 2181.
Thank you.
And your name, sir?
Not giving it.
Oh, okay. Would you feel comfortable in our line of work if you had
I'm
someone
not
who
answering
was-
any of your questions.
Who's the George you know?
Someone's en route.
Huh?
Someone's en route. I'm not sure who. You can make this a lot easier if you would just explain what you're doing here and let us know who you are.
Sir, I told you, I am out taking pictures in public. That's what I'm doing.
Right.
I walked all around the Civic Center taking pictures. This is the most advanced place in all of Surprise. I went to take pictures. I'm a photographer.
Okay.
Am I not allowed to do that?
The information I was given was that you were standing outside of our gate.
I was.
Okay.
Is that illegal? I was on a public sidewalk. I never entered your facility.
If you were a police officer,
I'm not a police officer.
if you were,
I'm not.
Would you find that concerning?
I don't understand what you're trying to say here, because a person standing on public facility,
Can I ask you a question?
you can ask me anything you want. I'm not going to answer, but you can ask.
I don't know why we're being mean, we're just trying to talk here.
Okay,
Right?
this is not a consensual encounter, first of all. I didn't ask for help. I don't need help. I'm standing here taking pictures in
We have
public.
detectives and police officers and other people leaving a secure facility in vehicles that are assigned to us. Some people work in undercover capacities, and we have a person out recording those as they're leaving vehicles.
Okay, how do I know that?
Well, how do we know who you are?
You don't know who I am.
That you're not a threat to us or
Well,
someone
if I was a
leaving
threat to us or threat to you, would I be out here in an orange vest, not trying to hide anything? I didn't run from you. I stood here right when you called me. I'm not trying to run. I'm not a threat. I'm no threat. I have no weapons. I would show you, but I'm afraid if I reach for my hip, something bad would happen. But I'm not going to do that. I have no weapons. I have no ill intent.
If you reach for an ID and let us...
Well, I don't have an ID and wouldn't show it to you if I did, because again, I have not committed a crime. If you can articulate a crime, I'll provide an ID. Until then, am I free to go?
You're not free to go at this time.
So I'm being detained.
It's investigative.
I'm being unlawfully detained. Yes or no? You're detaining me unlawfully.
You're not being unlawfully.
Sir, you're unlawfully detaining me. Do you suspect me of a crime?
Suspicious activity. That's legal grounds to detain you.
No, it is not. If I have committed a crime, read the law. You have not suspected me of committed a crime. I've committed no crime. You have no idea that I'm going to commit a crime. Therefore, you have no RAS. I don't have to explain anything to you. I have to explain to you nothing.
You really do when you're taking pictures.
I don't have to explain anything to you. When standing in a public space, anything I can see from public, I can take pictures of. That is my First Amendment right to do. And there's nothing that you can do to stop that. And you can't make a lawful activity suspicious. I'm sorry. If it makes you uncomfortable, find a new line of work. Because I'm not going to stop taking pictures because it makes you uncomfortable. I'm sorry. So unless, again, I'm being detained, I would like to be free to go.
So is that the rationale? You're just trying to make us uncomfortable?
I'm not trying to do anything. I'm trying to take pictures in public. You came out.
Pictures of people's license plates?
How do you know I took pictures of people's license plate? I can walk down the street and see a license plate. What does that mean to anything? See, I'm turning over to this guy right here. Look, he's got a license plate. What does that mean? I can walk by and see a license plate. That information is not accessible to the public. I don't know what this means. I can't look up somebody's license plate online and get anything from that.
I think you're being a little disingenuous if you think this is a little suspicious.
Are license plates accessible to the public?
A normal person wouldn't find this a little suspicious.
Well, I don't care if they find it suspicious because suspicious is not illegal. And again, am I being detained?
You are.
Okay.
You're not free to leave right now.
Okay, well then I'm going to remain quiet. I'm not answering any more questions.
Okay.
First Amendment protected activity, and they find it suspicious, everyone. So I'm going to reach for my phone, and that's it. Only my phone's in my pocket, okay?
Nice and slow.
You got it. Just a cell phone. Now you're going to be live streamed. So again, am I being detained or am I free to go?
You're being detained.
I want to speak to you today about an issue that comes up quite frequently with my clients, and that is, should they speak to the police? Should they speak to the police before they get an attorney? Should they speak to the police after they've hired an attorney? That's the question I'm going to answer today.
See what's going on?
What's going on?
You're videotaping the jail. What's the reason?
No particular reason.
Well, it is a secure facility, though.
Okay.
What are your intentions?
What are my intentions? Go find a Whataburger and get some dinner here in just a minute.
Do you have ID on you?
Are you a police officer?
Yes, sir, I am. You're a deputy.
Okay.
Do you have the ID on you?
Are you detaining me?
I need to see your ID.
I'm not with CID.
You need to see your ID. I'm requesting to see your ID, sir.
I'd rather not give it.
I need to see your ID.
It's just like a circular conversation.
I need to see your ID because if something happens to one of my officers or something, I need to have your name under for person of interest or something.
Okay. Just put good citizen in your report.
In order to understand why you shouldn't talk to the police if you've been accused of a crime, you first have to understand how our legal system works. Our legal system is what they call an adversarial system. An adversarial system is different than, say, an inquisitorial system like some European countries have. In an inquisitorial system, the judge takes an active role in the investigation of the case. In our system, in the adversarial system, the judge doesn't take a role in the investigation. He's what they call a neutral magistrate. And in our system, the neutral magistrate acts as a sort of referee between two competing sides. In a criminal case, that would be the prosecution and the defense. The theory behind the adversarial system, and the reason some people believe that it's a good system, is that when two sides are competing, the idea is that the victory between those two will be justice. Whether that's true or not, and what the likelihood of that is always up for debate, but that is the theory behind the system. You also need to understand what the police believe their role is in the adversarial system. Now, it's hard to say what any particular police officer may believe their role is, but in general, police officers quite frequently see their role in the adversarial system as being on the prosecutor's team. They see themselves as a player in the adversarial system. What this means is that the police officer is not on your team. We often see the results of the police seeing themselves this way in the way they conduct their investigations. We see them turning your words on you, being selective in their investigation of the evidence, picking the things that may help their case, ignoring the things that will not. When you see this type of behavior, that behavior is probably the direct result of the police officers seeing themselves as a player on the prosecution's team. They see it as their job to convict the defendant.
Forward. Sometimes people get in trouble for merely standing near others holding contraband, or if it is found nearby.
Look what we have here.
Police may try to get you to snitch on yourself or on others, but remember that police may legally lie to you, so don't get tricked into waiving your rights.
We know you bought this weed. That makes you part of a drug conspiracy. Now you give up your supplier, or else we're going to charge you as an accessory to drug trafficking.
I'm going to remain silent. I'd like to see a lawyer.
I'm going to remain silent. I'd like to see a lawyer. If you're being interrogated or you're under arrest, these magic words are your best legal protection. They're kind of like a legal condom. Say them with me.
I'm going to remain silent. I'd like to see a lawyer.
I seen you drop this, man. Just admit it's yours. It's a slap on the wrist. You make things difficult for me, and I'll charge you with possession and evidence tampering. That's a felony.
Don't get tricked. You know what to say. If police pressure you to snitch, you need a lawyer. Use the magic words.
Officer, I'm going to remain silent. I'd like to see a lawyer.
But remember, just because you ask for a lawyer doesn't mean they have to stop questioning you. If you keep talking, your words might still be used against you, so shut your mouth until you've seen a lawyer.
When you are first charged with a crime as a defendant, you have three very big advantages over the prosecution in the case. The first advantage you have is the right to remain silent. That means that they can't force you to talk. They can't make you talk, which is very important in a topic like this when we're discussing whether you should speak with the police or not. The second thing you have is a presumption of innocence, which means that you're presumed to be innocent until the state can prove otherwise, and they must prove that at a trial, which leads us to your third biggest advantage, and that is that it's the state's burden to prove their case beyond a reasonable doubt. You start off in a very good position in a criminal case with huge advantages over the prosecution. But when you choose to speak to the police, first of all, you're waiving your right to remain silent, which means you're giving up one of your big advantages in the case. And then that can then in turn be used to overcome your presumption of innocence at a trial, and it works to bolster the state's case to prove their case beyond a reasonable doubt. Quickly, your case will begin to fall apart. And as you can see in criminal cases today, in jurisdictions across the United States, prosecutions have very high conviction rates. And the reason they do is because of mistakes that defendants make on a daily basis. One of them is speaking to the police.
I haven't did anything that you asked me to do. You haven't asked me to do anything.
I told you to step out.
You didn't tell me to step out. You want me to step out?
No, not right now.
Okay.
I'm gonna wait now.
That's fine. but your hand doesn't need to be on me. I'm sitting here, my hands are in plain sight.
Yeah, it's affirmative.
Ask for the watch commander, please.
We'll get to that in a minute.
Okay, I need your horsepower.
We'll get to all that.
Okay.
And good time.
Right.
No, don't be reaching.
Man, I'm taking it.
Don't be reaching.
You put your gun is shaking, and you pointing your gun at my head.
Pointing my gun at your head. Don't fucking reach. I told you not.
Man, I took my earpiece
do
off.
not fucking reach.
Man, you need to put your weapon down. You need to put your weapon down, man.
I'm not gonna do nothing.
Hey, you need to get over here, senior. He's got his weapon at me and he's shaking.
What's going on right now?
It's nothing going on, deputy. He's got his weapon pointed at my head. I haven't done a thing. He came up here. He put his hands on me. I asked for a watch commander. He's pulling his weapon on me. For what? For what?
I told you what for.
For what?
You're not listening to my commands. Not that I know of.
For what? What is he pulling his weapon on me for? I asked for his watch commander. You the sergeant.
Keep your hands on the steering wheel. Put your hands on the steering wheel.
Hey, your guy
Put your hands on the steering wheel.
You seen your sergeant's here.
On the fucking
Would you tell him to drop?
What's going on?
Why is your officer cursing at me?
What's going on?
Why is your officer cursing at me?
Just do what he tell you.
Excuse me, sergeant.
I understand.
My hands were in plain sight when he came up. I put my hands out in plain sight. Okay? He asked me. He started being basically disrespectful, telling me, what am I doing here? Would you please tell him to put his weapon down?
What do you... You got the taser?
Bonnie's getting it. Bonnie's getting it.
What's going on? What are you doing here?
I'm code 5.
Where you work?
Where do I work? I work as a private investigator. And I just got through dealing with this in federal court with you guys. He pulled his weapon. All I did was remove my earpiece, and he pulled his weapon and pointed at my head. And he's still pointing his weapon at my head. I'm asking you to tell him to holster his weapon.
So what we'll do, we'll go ahead and we'll back it up. Back it up. Keep your hands up. We're going to have you come out so we can figure out what's going on.
That's fine.
Okay.
That's fine.
Back it up. Take it out.
I got it.
But you may say, I'm innocent. I want the police to know that, so they don't charge me with a crime, so that they don't take my reputation and drag it through the mud. And I can understand that. So the next question you have to ask yourself is, what can be gained by speaking to the police? Can I convince them that I'm innocent? Well, first you have to remember, like we talked about earlier, who they are and who they work for, and who they believe they work for, and what they believe their role is in the adversarial system. Because of the way they view their position here, they're going to twist your words. They're going to give your the words you say an uncharitable interpretation. Another problem that I see quite frequently when we go to trial on cases like this is they're going to ask you questions that a prosecutor would never be able to ask you at a jury trial. First of all, because you have a right to remain silent, so they would never actually even get to ask you questions if you chose not to take the stand. But if you did choose to take the stand, we would be able to object to certain questions they may ask, maybe questions that call for speculation, or questions that may ask you about certain things that had happened to you, or that you had done in the past. And quite frequently, the police officers can ask you those questions in an interview that is audio taped, and then that audio tape comes into evidence at a trial, and then those questions can all be asked by the police officer in the audio. There are questions that they could have never asked you in that way at a jury trial without pulling an objection and having that objection sustained. And so that's another problem with speaking to the police. Another problem with speaking to the police is everything you say to the police in that interview will be used against you at some point. Let's say you say something incriminating, or at least something that they interpret as incriminating. Well, that's going to be used against you at a jury trial to try to convict you. Let's say that everything you say is perfect, that you completely absolve yourself of any criminal liability whatsoever. Well, and that doesn't happen very often, but I have seen it happen. And then what happens is, ultimately they take a plea deal sometime down the road. And at the sentencing hearing, the attorney attempts to argue, Judge, they've taken responsibility from the beginning, and they're taking responsibility and accountability here today. Well, naturally, the prosecutor gets up and says, Judge, that isn't what happened. They haven't taken responsibility and accountability from day one. In fact, the defendant denied everything on day one, and they refer back to the police officer's audio transcripts. So, as you can see, no matter what you say, at some point, what you say can be used against you. So that's another thing to take into consideration. Even if you handle the investigation perfectly, and you are perfect in answering police officers every question, which again doesn't happen very often, but if you do, it could still come back to bite you in the butt at some point.
Hello, Dale Carson, attorney, Jacksonville, Florida, author of the book Arrest to Prove Yourself. We've had a few questions pop up about the law, and I wanted to discuss with you this real sort of oddity with Miranda. Most of us know what the Miranda warnings are. They say, essentially, you have the right to remain silent. Anything you say can and will, both operative words, be used against you, and you have a right to a lawyer. That's pretty straightforward. And we would generally think that everybody should be advised of those rights before you talk to law enforcement. And as a rule, that works pretty well. If you're the target of an inquiry and you're going to be arrested or there's probable cause to arrest you, law enforcement's obligated to give you that warning. But they give it to you in such a way that you almost feel thankful that they gave you the warning, but you don't have anything to hide. After all, you're an American. And so you talk, which puts you in tremendous harm's way.
Another reason that you don't speak to the police is because everything you say can be used against you in trial. But let's go back to this scenario where you said everything perfectly, that you did everything that you were supposed to do in that interview and didn't make any mistakes. Well, none of that stuff can be used to help you at the trial. Now, this is because of the way the rules of evidence work. The rules of evidence will allow prior inconsistent statements to be used against you at a trial. That's one of the rules of evidence is for impeachment purposes. So if you say one thing in the police interview, but then you come to trial and say something different, they can use what you said in the police interview against you to impeach you. But what can't be used at a trial, except under very limited circumstances, is prior consistent statements. So if you come to trial and you say something, and then you want to say, well, that's also what I said before to the police, you're not going to get to say that, except in some very particular circumstances. So, in summary, the rules of evidence will allow all the bad stuff to come in, and they'll keep out all the good stuff that you said in that interview. So the interview will be a complete waste of time for you. It will only help the prosecution. It will not help your defense.
That's something you'd never want to do. And under a 2013 case called Salinas v. Texas, the Supreme Court made this odd ruling. Salinas went down to the sheriff's office to kind of avoid being targeted in a homicide case. And because he was there voluntarily and he wasn't a target of an investigation, they started interviewing him. And they didn't advise him of his rights. Even though I've got to be candid, I don't think the advisal of rights to suspects really stops them from talking, because it's all a matter of tone and delivery and body language, which creates this illusion in suspects that you can talk with impunity and the officer, after all, is simply there to help you. But in this particular case, they asked him and he gave a long statement, and then they asked if they could check his shotgun and would it have shell casings in it similar to the ones that were found at the scene. And he didn't say anything at all. He just got really nervous. He bit his lip. He started sweating and shuffling his feet. He wouldn't think much about that. So he went on about his business, having not said anything. And later he was picked up on a traffic violation, and they charged him with, get this, murder. And the Supreme Court ruled that that was okay, that his physical actions could be reported, and in fact were in this case, We don't know at this juncture whether or not he was actually later convicted of the homicide, but that's really not the point.
One worry that my clients frequently have is that their silence will be used against them. And they want to talk to the police. They want to talk to the prosecutor. They want to tell them that they're innocent. And they hope that speaking to them will convince them that they're innocent and that they shouldn't be charged. Well, that's not going to happen. The police already think you're guilty. It's their job to convict you. The prosecution thinks they're guilty. They've charged you. Talking to them isn't going to make a difference. But what's more important is what the jury thinks, because they're the ones that have the ultimate decision of deciding whether you're guilty or not guilty. This is what's important to understand. First of all, the prosecution cannot argue that you were silent, therefore you must be guilty. In fact, if they make that argument, you'll probably get a new trial. The courts have determined that that is such a damaging argument to the defense's case that it's unfair and that it cannot be used as an argument at trial. Further, the judge is going to instruct the jury that you do not have to take the stand, you do not have to speak, and that the jury cannot use that as evidence of guilt, that they cannot infer from your decision not to take the stand that you're guilty. And so there's many checks along the way. They're going to make sure that the jury does not take your silence as evidence of guilt. That's your right. That's what goes along with the right to remain silent.
The point is, even if your lawyer is sitting with you, I can't prevent my client from reacting to a question put to them by law enforcement. Did your client kill somebody? And there you are sitting, the sweat's pouring off your face, and you've got dry lips. I mean, come on, if that can be used against you, that hurts you. And no, it's not testimony in the sense of an oral statement. It's still a lead for the government to use. So even if your lawyer is present with you when you've been accused of a crime, you shouldn't be there. Your lawyer can certainly be there by herself, but you shouldn't be there for those very obvious reasons. The law is changing every day. Tomorrow there'll be something different. You owe yourself the benefit of understanding the law so you don't just accidentally put yourself in harm's way.
Yes or no? Are you acting under your oath?
I
ask you a simple question.
You
You're the
smoking something,
servant.
right?
You're the one that's obligated. You're already violating your patrol guide.
How am I violating patrol guide?
I asked you, what's your name, your shield number, and your command. What does your patrol guide tell you to do when
Shield
a
number.
person asks you that?
Shield number right here.
What is your name and your shield number? You have no shield showing.
I'm not telling you nothing.
You're not telling me anything.
No.
All right.
Let me see ID,
Am I
please.
free to go?
No, you're not free to go.
I'm not. Are you
So what
detaining
were you
me?
smoking then?
Are you detaining
I'm
me?
detaining you. You're detaining yourself. You're
You-
detaining
are-
yourself.
are you detaining me?
You're detaining
Okay.
yourself. You're
It's either
detaining
smoking-
either smoking a cigarette or you're smoking artificial cigarettes.
You're
right?
getting too close to me. You're violating my
You're getting too close to
personal
me
space.
too.
You're violating my
personal space.
You're violating my
You're
personal
violating your
space.
personal space.
What's your command?
Right here.
No, your command. Where you working on it? What's your command?
Listen, sir, we asked you for your ID.
You didn't ask me anything,
Yes,
and you didn't answer any question. No,
So
we.
I'm
There's
asking
no.
you, what were you smoking?
Are you acting under your oath?
I'm asking you what were you smoking.
Are you acting under your oath?
Smoking the artificial
I wasn't smoking.
Who can protect you, particularly if you get a phone call from law enforcement saying they want to talk to you. Because the answer to that is, let me check, I will get back to you. Not, oh, no problem, I'll be right down. We sometimes, as good people, believe that if we go down and talk to law enforcement, we are going to be able to avoid a potential criminal charge. But I can assure you, if they're talking to you, you are a potential target. Even if you're a witness. It's not so long ago that I had a client sitting right in this office whose boyfriend was a fugitive. And she was asked by law enforcement whether or not they'd had any communication, which she denied. I didn't deny it for her. She denied it. It was later determined that she had been in electronic text messaging communication with the fugitive. And the Jacksonville Sheriff's Office charged her as an accessory. So you've got to be very careful when dealing with law enforcement. About the only time you ever need their help And you don't have to worry about what you're saying is, my friend's drowning in the ditch over there, please rescue him. Or that house is on fire and I think there are children inside. That's probably not going to get you in trouble. But if you start talking about something in which you are a direct witness or you are a possible suspect, you're doing yourself an extreme disservice. So,
the reason that those who have been accused of a crime want to speak to the police is because they want to get their version of the facts out. They want to speak to the police. They want to show the police how credible they are and how the police should believe them over the other witnesses who are testifying against them. It's understandable that someone would feel that way, but they misunderstand how the system works. More often than not, the police see themselves as being on a team, and they see themselves and their job as to convict. And most of the time, very early on, the police pick someone who they're going to convict, and most of the time, the police are simply digging and mining for evidence. And so when you come in and you sit down to be interrogated, the police are digging for evidence against you. So that's more reason than any other to not speak to the police.
What's up, guys? What's going on?
Not a lot.
Not a lot? Why are you guys doing this?
Because we have the right to, sir. It's 100% legal.
Just trying to make a little extra money.
No, don't answer any of his questions. We have an absolute right to this. Don't answer any of his questions.
Can I see your guys'
Absolutely
business
not.
license, please?
Absolutely not. We're not required to have a license. Check your law, sir.
You're not required
Absolutely
to have a
not.
business license
Absolutely
to
not,
sell
sir.
items?
Absolutely not, sir. Check your law. It's our constitutional right. You can check into the city and California laws. Go ahead.
The clearest evidence that speaking to the police when you've been accused of a crime is a bad thing is that police officers themselves will not speak to the police when they have been accused of a crime. They exercise their right to remain silent. Another clear indication of this is attorneys will hire an attorney, be represented by an attorney, and more often than not, they will exercise their right to remain silent. Take the example of those who are in the know as to what the best course of action is. When police officers and attorneys themselves are exercising their right to remain silent, rather than trying to go to the police and get their side of the story in, you know that that's a good indication that you yourself should be exercising your right to remain silent and not speaking to the police.
Hi everyone, my name is Tim Zerillo and I'm shooting this video from Zerillo Law LLC in our offices at 103 Exchange Street in Portland, Maine on September 2nd, 2011. Thank you for watching this video. In this particular video, I just want to point out to you a distinction of a number of issues that I've discussed in previous videos on making sure to assert your right to remain silent. As I've told you before, silence is golden. How do you assert your right to remain silent? Well, in 2010, in a 5-4 decision in the United States Supreme Court, authored by Justice Kennedy, the case of Burgess v. Tompkins came down and really sort of, in my opinion at least, created a situation where an ordinary waiver of silence that would seem to apply doesn't apply. And I'll say what I mean by that. It's a little complicated, I know. In that particular case, there was approximately a 3-hour interrogation related to a murder of a murder suspect. The murder suspect, Tompkins, did nothing and said nothing that related to the case during those 3 hours. In effect, he just stood silent while questions were asked. Then the law enforcement officer decided to take a religious tract and started asking him questions about God, culminating in the question of, do you pray to God for shooting those boys down? To which Tompkins said yes. Now, his defense attorney quite promptly and properly said that that he had waived Miranda, or that he had not waived Miranda, but that he had asserted his right to silence during the 3 hours in which he said nothing. It would make sense, right? They asked a bunch of questions, he said nothing. Eventually, you should come to the point where you would think that this means that the person who is saying nothing wants to remain silent. However, that's not what the Supreme Court said. The Supreme Court said that you need to clearly and unequivocally assert your right to remain silent. So just saying nothing under Burgess v. Tompkins is not enough when the police are asking you questions if you intend to remain silent. So what do I tell my clients? Well, sometimes what I do is if they're really concerned, I give them the actual language on the back of one of my cards, and I can do that for you if you're concerned about a case you might be facing. But essentially the language says this: I am asserting my right to remain silent. I am asserting my right to counsel. I do not wish to answer any questions at this or any other time. Please do not answer me any questions. Please do not ask me any questions. Please contact my attorney, Timothy Zerillo, and direct all questions to him. I'd like the opportunity to make a phone call to my attorney. And that's about all it says. And I'll write that out for them on the back of one of my cards if they're concerned about the language of it. So just remember that if a law enforcement officer questions you and you want to remain silent, saying you want to remain silent is pretty important, as screwy as that sounds. But that's the United States Supreme Court's interpretation of it, so we live with it. So if you have any questions about this matter or any criminal case or any potential criminal case you think you might be facing, you of course give me a call. There are 3 other lawyers who practice criminal law at Zerillo Law who work for me, all very competent and very skilled lawyers, and of course I do as well myself. But we have a number of people in our practice who can help you out, myself included. For the office number, it's 347-6063, 347-6063 in the 207 area code. We're in Maine and we serve the entire state of Maine. I have cases all over the state actually, from Aroostook County to Ellsworth to, of course, a lot in Portland and elsewhere. You can also go on the web to find out more about myself or about other lawyers in the firm or about the firm in general at www.getzerillo.com. That's www.getzerillo.com. Hope to be talking to you soon, and thanks for watching this video.
Hello everyone, my name is Brandon Davies. I'm a criminal defense lawyer in Overland Park, Kansas, and I'm making this video because I want you to exercise your rights. Now, when people choose to exercise their rights, it's usually when they're interacting with the police. In my opinion, there's really 2 schools of thought when it comes to an individual acting with or engaging in any type of communication with the police. There's the first type, which want to know their rights, are willing to spend the time to know their rights, and then exercise those rights in a lawful manner. And then the other group, the other school of thought, is everyone else, the go along to get along folks. The people that, when they interact with the police, say to themselves, well, I haven't done anything wrong, I've got nothing to hide, this person's just doing their job, things like that. Those are the people who just talk to the police, tell them to do whatever the police tell them to do, and take what the police say as fact. I want you to be the first type. I want you to know your rights, I want you to spend the time to know your rights, and I want you to exercise your rights whenever you interact with the police. Going back to the 2 different types of people, the second type, or the go along to get along folks, will often look at the people that are exercising their rights negatively. They'll say something along the lines of, why are you being so difficult? What are you trying to hide? Why are you, this cop's just trying to do his job. Why are you being like this? Those aren't the people that have the forthright to stand up for their rights. Those are the people that are going to dismiss their rights, just cavalierly give them away, and not take into consideration the fact that many people for generations have fought and died to protect those rights and give you those rights. They just want to give them away because it's more convenient, or they don't want to spend the time to know them. Now, the question I'm going to be answering in this video is, the first question, and almost the principal question that any officer is going to ask you whenever they interact with you. The first thing they're going to say is, let me see your driver's license, or give me identify yourself.
Journalist working on a story. I'm gathering content
For me,
For
I'm an
you.
independent journalist, yeah.
You're not telling me what you're going to do with this information.
I'm a journalist. I'm going to publish a story.
On?
The constables.
What about the constables?
It's not published yet. I don't want to say, sir.
Well, why? What are you trying to do, hang us?
What do you mean, hang you? What does this talk about? I've never said that. You said that.
I'm asking questions. I'm trying to find out what's going on.
I just told you. I'm taking pictures. There's no.
But you're not telling me nothing.
There's
You're being
no,
real elusive.
Okay, there's no reason to get upset. And there's,
I'm not upset.
Okay, there's no reason to be nervous or.
You haven't been watching the news. You don't see what's going on.
Well, don't be concerned about what I'm doing. It's not a big deal. I don't have any weapons. You can search me if you want.
You got any ID?
I got an ID, yeah.
Let me see it.
No, I don't want to give you that.
You got no choice.
Who says?
I'm a police officer and I'm asking you for your ID.
I don't have to give it to you.
Yes, you do. I'm gonna find out who you are.
Okay, sir. Are you familiar with Penal Code 3802? You know I don't.
This video is going to tell you when you don't have to, when and when you have to do those things. When you have to give them your driver's license, or when you can say no or refuse to identify yourself. Now, whenever you're talking about this subject, you have to clarify that there are two different ways to identify yourself that we're talking about here. The first one is to produce a driver's license. The second one is to just tell them your first and last name and not produce some sort of physical manifestation or documentation of your identity. Let's talk about the first one. When do you have to produce your driver's license? Now, there's only two scenarios in which you have to produce a driver's license. The first one is when you are driving a vehicle. Key, you have to be driving the vehicle, and then you get pulled over for some sort of traffic violation, or there's some articulable fact that an officer can produce that makes him have reasonable suspicion to believe that you are involved in criminal activity, whether that be committing a crime or about to commit a crime. So that's just like, if you think about that, that's a regular traffic stop. An officer pulls you over for speeding. You've broken the law. An officer has a right to have you identify yourself in association with breaking that law. Okay? The second way that an officer can ask you for your driver's license or make you produce a driver's license, is at a valid checkpoint, whether that be a DUI checkpoint or a driver's license checkpoint. Now, the only time that you have to actually produce the physical license is if that checkpoint comports with Brown v. Texas, which is a Supreme Court case which lays out a test for whether that checkpoint is valid or not. And that test has 13 different considerations. I'm not going to go through all of those in this video or it'd be very long. But the general idea is if you get pulled over at a checkpoint, you can assume that it's a valid checkpoint. Unless if they are pulling everyone over. Generally, that's going to be a valid checkpoint if they meet the other 13 or have some combination of the other 13 factors. Assume that they probably do. So if it comports with Brown v. Texas, and the principal one is if they're pulling everyone over. They can't just be pulling random people over and asking them for their driver's license. That does not comport with the Brown v. Texas. They have to pull everyone over. That's the second way that they can have you produce your license. Only in those two scenarios are you required to produce a license. Now, that isn't whenever well, let's move on to identification. When you can have to identify yourself other than producing some physical document. The only way you have to identify yourself to any officer is if the officer has reasonable suspicion to believe that a crime is being committed, or you're about to commit a crime, or you're involved in criminal activity. That is the only time that you have to identify yourself to an officer. The officer has to have some sort of articulable facts to establish reasonable suspicion. So the next question most people want to know is, well, what's reasonable suspicion? Reasonable suspicion, unfortunately, isn't clearly defined by the Supreme Court. The Supreme Court has given us some guidance saying it's less than probable cause, but there's no clear definition of what reasonable suspicion is. They basically say it has to be determined on each and every scenario's set of facts. kind of weighing a probability the person is committing a crime. But they have laid out a way that you can figure out if the officer has a reasonable suspicion. Because that's the only time when you have to give up your ID or have to tell them your identification. And what you need to do is simply ask. Ask this question: am I being detained? If the officer says yes, then only way he can detain you legally is if he has reasonable suspicion that you are committing a crime, about to commit a crime, or involved in criminal activity. That's it. If the officer doesn't say you're being detained, they'll say you're free to go. That's when you've won the battle. That's when you've effectively exercised your rights. If the officer says you're free to go, leave the scene. Don't sit around and gloat. Don't sit around and try to interact with the officer in any other mechanism. Just leave the scene. You've won. You've exercised your rights. So go to our blog, read the article, exercise your rights. Don't let the folks that want to intimidate you and say go along to get along, and that you're being difficult and that somehow it's your fault or you should be held in negatively because you're exercising your rights. Don't believe those folks. A lot of people have fought and died for those rights, and it's your obligation to uphold them and to question the authority whenever an officer tries to interact with you and elicit information from you. Thanks for watching our video. Have a good day.
My name is David Payne. I practice law in Asheville, North Carolina at a law firm known as David R. Payne, PA. I've been practicing law for 22 years in Asheville. I do both federal and state criminal work. And one of the most common questions I have related to criminal issues surrounds the concept of talking to the police. I just finished a DWI trial this week, and we won the trial, but during the trial a lot of language made its way into evidence, if you will, related to what my client told the police officer. Now, my client was an extremely truthful, honest, wonderful individual, but she indicated that she had had 3 beers. She actually said the type of beer and the time that she drank those beers. But all that was heard into evidence, or at least was presented into evidence, was, I had 3 beers. Which immediately leads one to the presumption that, well, obviously she was intoxicated. We were able, through other evidence, to negate that and to have her eventually found not guilty. But what if that other evidence had not been available? All we would have had in that situation was what she said coming from a uniformed police officer sitting on a stand. The Fifth Amendment of the Constitution of the United States says a person shall not be compelled in any criminal case to be a witness against himself. Here's the number one question I have. What do I say to the police when they stop me? What do I say to the police at a DUI checkpoint? What do I say to the police when they pull me over at night? Let me inform you right now that there is nothing you can say to the police that will in any way exonerate you or make them feel differently about you. A lot of people think, well, if I can just talk, I'll get my way out of this situation. The Fifth Amendment of the United States Constitution was drafted for you. It was also drafted for the police. It protects us all. And our advice is very simple. You say nothing. Nothing. Here's what I mean by that. A lot of times the first thing they'll ask you is, may I see your license and registration? I would give them my license and registration. Wouldn't have a problem with that. The second thing they'll ask you, typically, is, have you had anything to drink tonight? At that point, I would look at the officer and I would say something like this. Officer, with all due respect, I'm not going to answer questions from you. Period. Now, they don't like that. So they'll ask again. Sometimes they'll say something like this. What, do you have something to hide? Why aren't you talking to me? You again reiterate the fact that, officer, I will not answer questions. If the officer directs you to do something, for example, pull your car over, I want you to say something like this. Are you demanding that I move my car over? Yes or no? In other words, you ask the questions. The first thing that should come out of your mouth when a police officer pulls you over or stops you at a DUI checkpoint is, why did you stop me? Why are you pulling me over? What are you doing here? Especially in a DUI checkpoint. Have I done anything wrong? And you'll hear them say, no, this is just a checkpoint. We just want to make sure that no one's out drinking or driving. Have you had anything to drink tonight? Officer, with all due respect, I will not answer questions. Now, a lot of people think that just makes him suspicious and he thinks immediately that you've drank. Well, what if you're trying to be truthful? And what if you said something like this? Well, yeah, officer, I did have a drink about 4 hours ago. I had a glass of wine with my spaghetti. Do you think that's going to stop him from any further inquiry? Oh, okay, well, thanks for telling me that. You go on about your business and have a nice night. No. What he's going to do at that point is get you out, give you a field sobriety test, and give you a breathalyzer test to see if you are in fact intoxicated. The more appropriate question, which I still wouldn't answer, would be something like this. Are you intoxicated or are you impaired while you're driving? See, it's not illegal in the state of North Carolina to consume alcohol and to operate a vehicle as long as you're not impaired. And typically that impairment number is 0.08 or higher. It used to be 0.15 or 1.5, then it went down to 1.0, then it went down to 0.08. So the issue of impairment is the true issue. My point is this. What do I say to the police? The answer is nothing. With all due respect, officer, I'm not going to answer any questions. Can you tell me why you stopped me? He needs to be able to articulate that. She needs to be able to articulate that. And quite frankly, if you have an iPhone, I tell my clients, turn them on. Turn on the iPhone, keep it on the entire time so that you can record the events. Officer, why have you stopped me? Well, I stopped you because you were weaving. Well, how was I weaving? You start asking the questions that you want the answers to. How was I weaving? Was I speeding? Was I weaving within my lane? Was I weaving in somebody else's lane? Was I exceeding the speed limit? What infraction did I violate? What did I do wrongly to justify you stopping me? That's the question you need to ask. Be careful getting into discourse. I'm not saying don't utter a word. I'm saying ask questions, but watch out for dialogue between you and the officer. You want to ask them why they stopped you. You don't want to be engaged in a conversation where eventually he comes back around to, so where'd you have dinner tonight? I ate at XYZ restaurant. Oh, they have a good wine list there, don't they? Well, yes, as a matter of fact, they do. Do you like red wine or white wine? Well, I like red wine. Did you have any tonight? Well, yes, I did. But I'm not intoxicated. Please step out of the car. That type of conversation is what you want to avoid. You ask the questions, and if he says pull over, it's fine. You need to cooperate. If your license and registration check out, then you need to continue to ask the following question. Are you detaining me If you are, why are you detaining me? I detect the odor of alcohol. Okay, thank you. You don't want to say, I didn't drink anything, or I only drank one. You just say, thank you for answering my question. Remember, you have 30 minutes to call and get a witness. So if they're going to start their field sobriety test or breathalyzer test, etc., you need to say something like this. Are you now going to test me? Yes, I am. Well, under the statutes of North Carolina, I'm giving you notice at this point in time that I'm going to be calling a witness. We now have 30 minutes from this time. I will sit in my car and I will wait on my witness. Do you have to talk? No. Be extremely leery, be very wary of police officers who say, well, the reason you're not talking is because you're hiding something. I would suggest the response would be something like this. The reason I'm not talking is because the Constitution of the United States of America says that you, under any circumstances, for any reason, cannot compel me to talk. And you're not to infer guilt or innocence from my silence. There's nothing wrong with simply keeping your mouth shut. We encourage you to contact us, 828-258-0076, or on the web, www.drplawfirm.com. Thanks.